Good morning, everyone. We're going to start on time, as requested by the CPDP organizers. So, welcome to this panel on location privacy, which problems, which solutions. This is a panel sponsored by the KU Leuven and the Vrije Universiteit Brussel. The VUB is sponsored by a joint project that we have, an interdisciplinary project on location privacy funded by the VO, the Flemish Science Foundation. This panel I will give a very, very brief introduction, and we will then have very short presentations from the speakers. They will have 4 minutes each to give an initial position statement, a very short position statement, and then Mireille Hildebrandt will lead the discussion as moderator, and we will then have a session of questions and answers from the public. So in this panel, the questions we want to look into are, okay, what is the problem with location privacy? Why should we be concerned? Many of you have probably already thought about this, but I think we have some new interesting perspectives to look into in this panel. How can we protect location privacy from a legal perspective and from a technical perspective? We don't want to focus just on the European Union. We want to look beyond in the world. So what are the problems of location privacy in other countries as well, beyond Europe? And we also want to look at possible frictions between the right to privacy and the right to conduct a business. I am Claudia Diaz from the KU Leuven, a professor in privacy technology at the KU Leuven. I will be chairing this panel. The panel is moderated by Mireille Hildebrandt. Mireille is a professor of law and philosophy of law at 3 different places, in Rotterdam, Nijmegen, and Brussels at the VUB. She teaches master's students about law in cyberspace, and as such, she is sort of interfacing between law and data science. And she has a new book coming up in March on the new animism of data-driven society. We have 4 speakers in this panel. Linnet Taylor, who will speak first. She is a Marie Curie fellow at the University of Amsterdam, Faculty of International Development, and her research is on the use of new types of data in research and policy making with respect to development, urban planning, and mobility. Our second panelist is Rosa Barcelo. She's head of sector at DG Connect in the European Commission, and she is involved with the update and implementation of the e-privacy directive. Our third speaker is Laura Tielemans. Laura is a doctoral student at the VUB, the Faculty of Law, so also a lawyer, and her research is on the right to privacy and data protection with respect to location data. And our last speaker and only man in the panel is Michael Herrmann. He's a doctoral student at the KU Leuven, and his research is on location privacy technologies, and also on he's also looking into the data that is leaked by location, by mobile applications. So with this very brief introduction, I want to move to the position statements of the speakers. And our first speaker is Linnet. Do you have a microphone?
Yes, I do. Thanks. Thank you. So I became interested in this through the lens of development studies. I started off in ICT for D, and there's a lot of discourse about how positive mobile phones are for the developing world. And when I started studying big data at Oxford a couple of years ago, I started wondering what the possible risks were of all of these people emitting their data all over low and middle income countries all over the world, and this being picked up by corporations and donated free of charge to organizations like the United Nations. It all sounds very innocuous and positive, in fact, but when you look at the type of location privacy issues it brings up, it gets very interesting. For a start, there are new granularities involved in this. Data on the developing world has traditionally been fairly sparse and fairly bad. It's often sponsored by USAID, by large country coalitions or donor coalitions who are interested in statistical data, census data, that countries can't afford to collect themselves. And so you get household surveys, but they're very much oriented towards health, towards development issues, towards poverty. And what we see now is, particularly with mobile phone use, there's 6.3 billion mobile phones, 3.9 of them are now in developing countries. We see people in countries where they don't have access to information about technology, being part of technology and emitting data about themselves constantly, emitting a 360-degree picture of what they're doing financially, behaviorally, socially, 24 hours a day, pretty much. And this is problematic first because it offers new granularities and new levels of legibility. and also because who it offers those granularities and legibilities to. It's not necessarily to traditional development donors. It's more to huge international corporations who then can donate the data anywhere they want, because generally in user agreements it says, we can use your data for research purposes. And in the law it says you can use people's data freely if it's for their, well, if it's for humanitarian reasons. And people tend to classify development, public health as being humanitarian uses of the data. So there's really very little stopping corporations from sending the data any place they want for any kind of analytics they want. This can lead to new types of risks to data subjects, I'm arguing. Tracking restriction of free movement. For instance, it's possible the mobile phone could serve as the new passport for people who want to travel across the Mediterranean to Europe, undocumented. You can argue that they shouldn't be doing that, but there's also an important factor there where you can see from their mobile phones where they come from because of where their contract is from. If that data gets shared, it's no use if they destroy their passport. They're completely identifiable, even if not by name, by the authorities. Big data can also proxy for restricted categories. By your network, we can tell your religion, your age, who you're associating with politically. In some areas where people are being persecuted or subject to ethnic violence, for instance, this can be hugely problematic. Calling patterns or an active leader of a group make groups trackable across space as networks. So you don't even have to be individually identifiable. You can be identifiable as part of a group. For instance, in Ukraine, in the protests, at the start of the Kiev protests, the government was able to hack the cell phone signal, you probably all know this already, and send out messages to all of the protesters based on their existence in that area, in that location, rather than based on their subscription to the network. So they don't have to know who you are, they just have to know where you are. Also, you can, Blumenstock has demonstrated you can nest a specific survey within a mobile phone call data record set, which will tell you exactly what everybody in the set is doing. So you find out from just a few people in a particular CDR what their job is, where they live, who their friends are, and from that you can infer a lot of detail about absolutely everybody who is purportedly anonymous in that data set. I would also argue that the politics of data access tend to be what I'm calling flattened by development motives, and particularly by humanitarian motives. If you look at one of the more famous examples, the use of mobile phone data from Haiti after the 2011 earthquake, first to locate people who were in trouble, and second to locate the spread of cholera through Haiti after, from Port-au-Prince after the earthquake. What we see is that, first of all, companies will donate mobile data freely to researchers so that people can be found and tracked for their own benefit. After that, that data is just out there. It's traveling through channels within the United Nations. It's potentially traveling back to the Haitian government, whatever that may be at the time that it reaches them. And it may well be used for motives which are not quite so pure as saving people from cholera or finding them when they're trapped under rubble. And so the half-life of data is hugely problematic when you talk about humanitarian uses. You don't just release it once and then get it back in the fold. You release it and it's out there. So that's what I'm working on. Thank you.
Thank you very much. So we move to our second speaker, who is Rosa Barcelo, talking about the current and upcoming legal regulation.
Thank you. I was going to start by saying that location data has privacy implications, but I think that Linnet was very graphic. Location data is data that is very sensitive and requires protection. And I'm also very happy to see that and to explain today that the EU legal framework specifically protects location data. We have a framework that sets the boundaries about what can be done and what cannot be done. So what I would like to do in these 3-4 minutes is to just sketch very briefly this existing EU legal framework on location data. So what is where do we find this framework? This framework basically has two legal tools. First one is the e-privacy directive. Article 9 specifically refers to location data and requires consent to process this data. This e-privacy directive applies to telecommunications operators. So when they process location data, cell antennas and base stations normally I refer. Then, in addition, we have the data protection directive. The data protection directive that applies to anyone else processing location data, which, for example, an application, a geolocalization application. Today when I came, I wanted to know how the best way to come, which tram I should use. So a typical geolocalization application users ask me already for my location data. So the frame and applies to the operating system, which usually also processes your location data, or an employee processing location data. In essence, the Data Protection Directive has more possibilities than consent, but data protection authorities interpreting the law basically have boiled down to say consent is also necessary. So our framework, this is a simplification, but in general requires the consent of the user to protect, to process location data. So for that we could be, well, we are quite good. The situation in Europe as opposed to, for example, this case that Linnet mentioned is pretty good. But then when you look closer, and you might find challenges or concerns or about how this framework is implemented in practice, how we apply it, and whether indeed it provides the protection that on paper we already have, or we think we have. So just to give you a few ideas about these potential concerns is 3 points. First is information. So the framework requires to inform people that their data is, the location data is processed, for what purposes, to whom is provided. And the question to you and that I pose in general is when we look at how the providers inform people, we see different ways. For example, we see that telcos used to put that in the conditions of the contract when you subscribe. And the question is this good? Is this effective? Does somebody who signs a contract for a GSA to have a subscription really is well informed in that way? I'm not sure. Now we see other ways of informing that maybe are more intuitive, and we see them evolving. I'm sure you realize when your data is location data is processed. We see now in the application the little symbol, a black thing, and is covered inside. In the operating systems are designed in that way. And is this better? Maybe it's better, but I think my sense is that there is a long ways to go to achieve the purpose of informing individuals. And then I jump to the next one very quickly. Is very related is consent. People are supposed to say yes and no. Do I want to be? Do I want my data to be taken? And here again, we see the general, the old ways. I sign a contract. And new ones, I have to download that application saying yes. I have to turn the little thing that yes, I want it. And here again, the question is this effective? Is this meaningful? Does it achieve what it's supposed to? And last little point is this framework that I explained, and I still think that is a good framework, is a little bit complex. As we saw, some people is under a legal tool, others are under another legal tool, Wi-Fi. So it's a little bit of complexity that one might find it not helpful. So I'll leave it here for Laura to continue and deeper in that.
Hi. So today I will speak about the freedom to conduct a business on one hand and the right to have a data protection and how to find that right balance. I looked into the law, as you just said, it's very complex, and to see if the legislator gives an idea of how to achieve that balance. What is interesting is that the freedom to conduct a business has gained the same legal value as the treaties with the Lisbon Treaty in 2009. On the other side, we see the right to data protection articulated in the Data Protection Directive on one hand, and on the e-privacy on the other. As soon as one of the directives applies, this immediately means that there will be a limitation on the freedom to conduct a business. Now, why is that? Firstly, because you need to look into the conditions of Article 6, meaning that you cannot just process data as a business. You need to do it fair, lawful, and also you need to specify a specific purpose to which you want to process the data. here you already find the first balancing test, because usually what businesses do nowadays is that they will just use the data for one purpose and then they want to go and process it further. Interestingly, the way it is right now is that the legislator give a little bit more margin towards data processors and controllers, because the second purpose does not necessarily need to comply with the first one. It just cannot be incompatible. Then next you have a second assessment, and this is what I wanted to talk a little bit more about today, is you have not only the first article that you need to comply with, but the second one, which is you can only process data on a specific legitimate ground. One of which is consent, which you mentioned, and another one is the F ground. So that means that data controllers can process data when it's in their legitimate interest. So again, here you see that the legislator gives a kind of margin towards data controllers and businesses in general to pursue their legitimate interest. And this is actually an articulation of the freedom to conduct a business, because why would businesses perform certain businesses to get money? And their legitimate interest, if we see in the case law of the court, usually just refers to an economic business. So this is an open-ended provision. And as stated before, the directive, because every member state needs to interpret it and transpose it to national law, has been just interpreted in different ways. Some see it as a last resort, and others see it as a very difficult kind of provision, because you need to look into it, and the law actually does not really mention how you could balance the legitimate interest on one hand and the interest of individuals to have data protection. It only says that you cannot process data if it's being overruled by fundamental rights and freedoms of data subjects. So to see what that actually means is that you have to go and look into case law, but up until now we do not really have a lot of case law that kind of balances the freedom to connect the business with the data protection. And you also can look into the Article 29 Working Party, which gives us guidelines and also clarifies that you need to perform a balancing act looking at the reasonable expectations of data subjects, what that legitimate interest actually means. Now, the interest is kind of linked to the purpose, because the purpose is a little bit more specific, whereas the interest is a little bit more broad. Now, they try to give a little bit more clarity in their regulations. So there, they changed the F ground, and they said that it also needs to comply with the reasonable expectations of data subjects. So they kind of already given a little bit more clarity as to where that balance is needed. But it's not yet there. And the third assessment, where you can see a limitation of businesses, is the right to object. So even if this balancing test is negative for the data subject under the F ground, it can still go to the data controller or the court or the DPA and object to the processing of the data. And also interesting right now is, again, a little bit more of the margin towards businesses, because data subjects need to explain why they have legitimate, compelling grounds as to why they want to have their data, the processing of data being stopped. And in the regulation, as it is right now, they kind of reverse that burden of proof, and they say that any data subject can object, and it's up to the data controller to actually give the legitimate reasoning why they need to process it further. So that's probably.
Thank you very much. We move to the last presentation from Michael. You will have to indicate me when you want me to change the slide.
So, hello everyone. I think now, as being the last panelist, kind of an obvious statement, but I guess every one of us here in this room engages in location-based services, either occasionally or perhaps even constantly. And since this is a privacy conference, I think most of us are aware that this involves also sharing location data, our location data, with multiple parties in the internet. And since for whatever reasons a service provider usually does not have a strong incentive to implement strong protecting mechanisms, a user finds himself in practice usually confronted with three choices. And the first choice is to use obfuscation techniques in order to hide the true whereabouts. But while using these obfuscation-based techniques comes with some disadvantages in practice. The second choice is, well, we could just all toss away our mobile device or our mobile apps, but, well, nobody's going to do that. And the third choice is, and this is usually the choice that we do every day, is we give up on our privacy. So in the remaining few minutes that I have for my opening statement, I'd like to give a little example to illustrate what kind of protecting mechanisms there could be on the example of a location sharing based service. So here in a location sharing based service, a user typically wants to share the location, the current location with a friend, for example. And this involves sharing this with a service provider. And well, some users may be aware that the location sharing based service will learn also then the location of the user. But what the user will not know, the typical user, is that this involves sharing the location with many other entities. So when we install a location-based app, usually this comes not only with software from the service provider, but also with third-party software. It just comes into our mobile device, and this third-party software may also access our location on a regular or irregular basis. And this is by no means to be supposed to be a complete list. It's just for illustration purposes. So another example could be the operating system in itself could already transmit your location data to the operating system developer. Another example is the hardware manufacturer may add mobile apps when shipping the mobile device, or modify the operating system in itself in order to make this device sending location data to its own servers. So, and that of course raises the question, what do all these entities do with the location data? There are numerous purposes. For example, some service providers may actually use this location data in order to improve their service, while other entities may engage in a rather controversial business of getting as much data of as many people as possible. And why do they do that? Well, they may aggregate this data, they try to make inferences about individuals with the goal to later then monetize this data, typically via advertisement. So being confronted with this, as I've already mentioned, obfuscation could be a means to protect our location data. And with this, there are several obfuscation strategies, and the key idea is, well, the user just alters the true location to something else, whatever that may be. So the idea here would be, instead of sharing precise location data, the user shares altered location data, and with the result that all the involved entities only learn obfuscated data and not precise data. So, but in our example of the location sharing based service, this of course comes with the disadvantage of the friend of the user only learning imprecise information. And this is maybe not what you want in a location based service, a location sharing based service. So finally, with the cryptography, the second category of protecting mechanisms I like to call cryptography based LPPMs. They use cryptographic primitives in order to build a private service in itself. And for location sharing based services, researchers have adopted encryption in order to protect location data. For example, I'm not sure if you can all see that, it says there on the bottom. Ordinary public key encryption, for example, or broadcast encryption. Proxy encryption is another, or homomorphic encryption has been applied to protect location data. And also other cryptographic primitives, such as private information retrieval, has been proposed to use. And in the for location sharing based service, this means whenever the user exposes the location, it encrypts it such that only intended receivers can decrypt it. So all the other entities may not be are not able to decrypt the message.
Okay. I want to thank all the panelists for their brevity in their statements. We are good with time. So I will now give the microphone to Mireille, who will lead the discussion between the panelists and ask them some questions until for the next half an hour, roughly, and then we will take questions from the audience.
Thank you very much. And I would like to start with this slide and ask a brief question to the audience. you're all undoubtedly very privacy aware people. But I would like to see your hands up who realized before seeing this slide that when you use a location-based service like Google Maps to get here or whatever other, that it is probably 7 or 8 companies, device manufacturers, operating system developers, third-party software developers, the location sharing service itself, and a number of fourth-party analytics, for instance, who already was aware of all these parties that have actually access to location data. What a great audience. Good, then we can now move on. Because it's obvious that this particular audience is more aware. And I'm hoping that at least we will give you some new insights. When I look at these sort of things, then I suspect that the main problem is in the reuse of data and in the repurposing of data. And I'm very impressed with the terminology that the first speaker used when she talked about the half-life of data. This is a term from nuclear energy. So the half-life of data. I think that's one to remember. It's a good metaphor. So my question would be, what can we learn from the half-life of data when we look at location data being picked up in countries and continents where data protection legislation is sort of absent? You have actually studied this. What can we learn about this for our own jurisdictions? Or is this just something about faraway countries?
I wish it were. I'm only studying faraway countries, but I can infer some points for the EU, for instance, which is that we don't, as researchers, always look hard enough at the gaps and the loopholes. We often look at what the law says can be done and assume that that's what's actually happening. And as you point out, even with companies that are developing apps, they're going to be sharing your data with many, many organizations, which may or may not keep it as secret as you would wish. So we need to look more closely at gaps and loopholes, including where information is legitimately, so to speak, disseminated for humanitarian purposes or for other seen as beneficial purposes. What happens to it next? I don't think there's enough research going on around that, and it probably needs to be qualitative, sort of anthropological, ethnographic research, following data chains by interviewing people, rather than making assumptions based on what is supposed to be happening. I think making yes and no equally possible choices for users is also really important. That's something that I'm looking at, is what does informed consent mean in a place where people haven't had the opportunity to fully understand the technology they're using, because it's not really current yet and because the information isn't flowing freely about that technology. I think that's probably true for a lot of less advantaged people in rich areas as well. I think it's a struggle for those of us in this room to fully understand user agreements. But I think that people we meet on the street every day probably have a lot more trouble than we do. And I think that people in lower middle income countries are often unfairly disadvantaged. But we need to look at who's suffering from that situation at home as well as abroad. And finally, I think it's really important to watch the distinction very carefully between personally identifiable information and anonymous data and what's actually going on out there. Because, as my research is showing, it's very, very hard to anonymize if you're looking as much at the group as at the individual, if effects happen as much to the group as to the individual. And it's not always just personal information that needs to be regulated, and I don't think we've even touched the surface of that yet.
I think that is a very good point about big data. But I want to go back to something that has been mentioned by basically all the speakers, and it's the story about consent. And I want to take a certain position myself and confront, for now, the lawyers with that. When I look at the European data protection framework, I would claim that consent is not the most obvious ground for processing. Consent can be withdrawn. That means it's also a very weak ground. Basically, if you have a contract with a service provider, that service provider is allowed to process the data, like location data, that it needs to perform the contract. if it wants to do anything else, then it has to go for consent. Now, I would like to ask Rosa, whose surname I cannot pronounce as well as Claudia.
Barcelo.
Fantastic. When you look at the e-privacy directive, the perspective is all about consent. There's a lot of talk about how meaningful consent is. When you look at the data protection directive, there are all these other grounds. And now when we look at the upcoming, if it comes up, data protection regulation, and we look very closely at Article 7.4, then it says that if you provide data that are necessary for the service that you're asking, okay, but if that service asks to reuse that data after they are no longer necessary, or if they ask you for other data, like your address book, we all know this, if they ask you for other data or for reuse, then they're not allowed to refuse you the service itself if you deny them that extra use. This sounds very complicated. Just a brief example. I need to provide my location, otherwise a location service cannot reach me. But what happens is that after I've provided that data, it's going to keep it to do statistics on it, but maybe also to reach back to me at another point. Now, the data protection regulation basically says it is not allowed to refuse that first service if you don't agree with reuse of your data. Do you think that's an important right? And I'm also going to address you a little bit as somebody from the Commission. Is this something that we are going to fight for? Because this seems to really empower people to say you can use the data only for the particular service that you're providing to me, and after that I want to have the technological guarantee that the data will be either anonymized or deleted.
I'm not going to answer exactly the question. Sorry. We proposed this rule, and we thought it was good. So let me deviate a little bit, and answer in more perhaps broader. I generally find that when we discuss location data in the EU, the debate tends to go in a way that is consent or not consent, and consent is important, is there, but consent is only one tiny part of the debate. We need consent, but then once the entity that has obtained the consent can process the data, it has all the other obligations that are under the data protection regulation. Security, access, and all of that. And I think that this is often minimized, and the whole debate on consent is maximized. Now, that to start. Second point is that there is a certain debate on whether consent is the right policy choice that was made to collect location data. One might say, well, to collect location data, you need consent, and then for other more sensitive health information, one might be able to do it without consent. And is this justified? I personally tend to think that it is justified, but I am also happy to say that maybe we need to go back and to engage in some of behavioral, sociological research on what users really think about that. And in the context of the review of the e-privacy directive, I don't know we'll have the possibility to do that, but this is something that I guess that I'm not sure it has been done in the EU, but it is. We see people sharing location data more and more, and maybe it's a time to go back and ask, how is it right to ask you for consent? It should be. Would you be happy if we will use your location data without consent? This is also something that I guess that anyone here could answer. Okay. So I'll leave it here.
Yes. So I'm going back to the audience. I'm sure you've all gone through this, so you want to have this app, or maybe many people here never use apps. That's of course possible, but imagine you have an app to supply you with the service. You need to give your location data for, let's say, 1 day. That's more than enough to provide you with the service. Now, it asks you for consent. It cannot ask you in the contract because the data are not necessary, but it asks you for consent for extra use and to look into your address book and a lot of other things. Now you say, no, let's not do that. I just want to give them the data that they need. If you say no, you don't get the service. That happens at this moment, let's say, in 80% of the cases. Under the upcoming regulation, that would not be allowed. So I'm going to ask you the question, do you think it is right that if you refuse to give data that are not necessary for the service that you're asking, that a company is allowed to say you're then not getting the service? Who thinks it's right that companies at this moment can say, in that case, you're not getting the service? Who thinks that's wrong? Okay, we have a divided audience. Now, this is a very interesting thing. I'm going to now turn the question around and I'm going to move to Laura. Imagine if a company like, let's say a navigation company, it gives you a service, you can use the navigator in your car. I'm not giving any examples. And that company says, now you can have an extra service based on statistics, but for that you have to give extra consent to use your location data for all kinds of statistics and for getting back to you. And that company says you can keep using the primary service if you refuse that, but you cannot use the extra service. So, for instance, we are not going to warn you about congestion if you refuse to leak your, to provide your location data continuously streaming to us, because then we cannot build the service. Now, from the perspective of the right to conduct business and the so-called F ground, I rather like F ground. The F ground is about the interest, the legitimate interest of the service provider, comma, balanced against the data protection and other fundamental rights of the data subjects. I always tell my students the F ground to some people sounds like the F word, but let's not go into any details there. How would you look at it from the right to conduct a business and from the perspective of the F ground? Do you think it's right that a company says, if you don't want to provide streaming location data for the coming 10 years, as long as you want to have this extra service, you're not getting the extra service because I think that's free riding?
I think that goes back to what I said earlier, that you have an obligation to specify your purpose. And here the question revolves in how you can further process the data. So legally, I think firstly you need to see if it's, like I said, like not incompatible. What I feel like business sometimes misunderstand is that if the balance test under the purpose limitation is negative, that they just think that, oh, okay, Article 7, the F ground, is just an alternative. However, they are cumulative. So you need to comply to the purpose limitation. So the further processing needs to be okay and not incompatible with the initial purpose. So you can have a data processing for a different purpose, as you mentioned, in the car. However, legally, you can't just jump to consent. Now, I know that for the e-privacy, that's like you always need to consent. But I think that from a legal point of view, we'll always get this balancing act. And so I don't think you can just hide to say, okay, if I didn't get a consent and it's not, and it's incompatible with my initial purpose, I'm just going to refuse, or I'm just going to start processing. And I think also refusing, I'm not sure how they in practice can enforce that, because I think, and maybe Michael can say a little bit more about that, that tracking and monitoring your data. As it is now, sometimes you give consent to the data controller, but how many of these parties actually also get the data, even if you didn't give your consent to them? So,
you want to connect with that, Michael?
Well, I would like to add something to this. With the legal framework, as a technical scholar, I have quite some difficulties to get my brains around this. But whether there is consent and whether consent is actually the right measure to process data, and whether or not to exclude people from services if they're not giving away all their data, these are very interesting questions. However, to me, I would like to emphasize that this scenario over here is also a result of our current architecture that we're using, such as, for example, the Android operating system. I mean, this is a disaster. Seriously, you want to download an app, and I recently migrated from iOS to Android. And in iOS, I had the feeling a little bit more I can set my privacy preferences. But with Android, I can just say, well, yes or no. And when I say yes to the service provider, I think of all the other software that comes down on my phone and gets the same permissions. And this is not the right security model. So from my technical perspective, we need to fix that. And after we fix that, I think the situation gets a lot better.
Can you save it till after the interpanel discussion, but please keep 10 minutes. I want to move one step further, and I'm going to ask that basically of the whole panel, but starting with our technical man. Now, we have all these choices, right? Yes. Once in a million years it happens. We have all these choices, 3 choices basically we gave you. You can throw out your privacy, you can throw out your mobile phone, so a choice, or you can start obfuscating. Now, when you look at the way data that is reused is at this moment employed, think big data analytics, then my proposition would be that the obfuscation choice is not a real choice, because it allows you to get away from the crowd. If you don't obfuscate, you do what you do what everybody basically does. So you're in the crowd. Nobody will watch you for that. The minute you begin to obfuscate, you get out of the crowd and you become very visible by obfuscating yourself. And you're going to be reconnected to your nearest neighbors. In computer science terms, they can live on the other side of the world, that's not the point. But those with whom you have something, 3 or 4 data points that can be observed anyway in common. So if we think of that, what does that mean for the consent situation? If you do not consent and you also manage to technically make that come true, what does it mean if it makes you very visible and profilable?
Well, I think what Mireille tries to poke me a little bit with is like this very specific obfuscation techniques. And for obfuscation, it is necessary to understand that this is not a guaranteed privacy protection. I cannot, by using obfuscation, I cannot guarantee that nobody ever will learn my true whereabouts. There are many, many other factors that come into play. And several obfuscation strategies are vulnerable to some attacks that, or if they're have been done wrongly, they are vulnerable to some sort of inference attack. So yes, while you may use some obfuscation techniques in order to fool someone that doesn't care, that's one side. But the other side is, well, what if you're confronted with someone that knows that you're obfuscating your location and actually tries to still pinpoint your location? So, and there, obfuscation may be, well, I mean, it may provide you with some privacy, but it is really necessary to understand that there are some limitations. And this is then a little bit better when we're talking about employing cryptography in order to build private services. But, well, maybe at a later point, I don't want to drift away too far. These also have disadvantages too.
Okay. Basically, you're making this proposition that I'm poking at you dependent on how good the cryptography is. But my point is, even if the cryptography is perfect, you are still alive, I hope. You're still walking around in the real world. And the real world is filled with sensors that you increasingly that you have no control about. So I would say this is not about how good the obfuscation is, but about the extent to which you're making yourself extra vulnerable if you begin to obfuscate. I would like to ask that same question to Linnet Taylor. How would you see in a place like Sub-Saharan Africa, where you've done a lot of research, what happens if people would be provided with the technical means to actually turn off location services or obfuscate in another way?
That's a really good question, because I think we're a couple of generations of phone away from all of this happening at this point. In most places in Sub-Saharan Africa, we don't have 3G connectivity yet. Really, I'd say 98% of Sub-Saharan Africa doesn't have any 3G. People are often using very primitive phones because there's really no use for data yet. And so what you have is companies that do have a fix on people through mobile phone antennae and through calling records, but you don't have the kind of flow of data that you have here. So the problems are in a way simpler, but I would say sociologically probably a lot more complicated, because there's a lot more violence, there's a lot higher scale of risk there. And so you both have simpler data and higher risk.
Yeah, so you're basically saying that the risk that if you begin to obfuscate, you will be profiled extra is not really yet a problem there.
No, I don't think it is. I think that goes along with all kinds of benefits, actually, of having more functioning telecommunication systems that unfortunately are not there yet.
Yeah, okay. Rosa, what is your, how would this impact consent? So if you know that if you're not giving consent, that this will actually make you more vulnerable. Is this something that the Commission takes into account when designing its or redesigning its e-privacy directive? And I'm not only thinking of commercial enterprise, of course.
Well, in the review of the e-privacy directive, the real review has not yet started. What we have done for the moment has been to commission a study. The study is ongoing. Is now the result will be delivered in a month or so. We asked the contractors to look into location data, to look as to whether the provision on consent is effective, is good, it delivers the protection that is needed. And also we asked them to look as to whether the fact that it only applies to telecommunication operators and that the other entities that we see here and all these operating systems and all of those are in another legal framework, whether this was the right approach, whether we should put them all together, or for example, everybody who collects location data that comes to the telecommunication, should they be all together? So the debate has been more on that, but not on the consequences of somebody saying, no, I want to be obfuscated. If this is something that is relevant, I would encourage anyone to reach us and to give us a position, because I think it would enrich the debate.
Yeah, because do you think that the default at this moment is that everybody gives consent because of the default settings of your device, of your operating system, of your of the software, of the apps, etc.? Would it be a solution, and I'm now again turning to all the others, would it be a solution if the as it's called, the regulator, I prefer to speak of the democratic legislator, would say the default shouldn't be like that. So the default should be that if you ask for a service, that you only provide the data that are necessary for that service. Anything above that should cost friction. There should be high transaction costs, to speak economically. For everything extra, might that mean that people who refuse that, who don't want their data to be used beyond for what is necessary, and I would say that that is the default of our data protection system. So if you would set that through, push that through, would that make it less obvious that you always give consent for everything, and that if you stop doing it, that you attract the attention of the secret services, the police, or whoever wants to sell things specifically to obfuscating type of individuals? You never know, there's probably a business model in that. Is there a solution somewhere there?
I jump to
Please.
that.
Yes,
I think that, again, I might not respond exactly to the question, but I think you are raising a question, is that the definition of consent. You said, well, should the defaults be? To me, the definition of consent is a key, crucial aspect here. And if you define consent as, I think it has been interpreted by the Working Party 29 as something that requires an affirmative action. So doing nothing doesn't mean consent. You cannot infer consent because the settings were set by somebody else to say yes. So if you require an action, this means that the individual will have to turn it on, download, do this, which is very relevant and makes the person more aware.
Yeah, sure. Actually, I was not talking about consent at all, but about contract. So I'm saying the default should be that if you make a contract, so you buy a service or you get a service for free, that's also basically based on a contract if you look at the terms of services. So you have a contract, that's 7b, that's a legal ground. You don't need any consent for that. You also cannot withdraw that. So it's a much more reliable business model for a company. So I'm trying to say, let's get away from that, always that same story about consent and opt-in and opt-out and human-machine interfacing, about whether people understand and blah, blah, blah. Let's say, for centuries we've said we have a deal, we have a contract, I will give you what you need to deliver me, and if you want anything extra, then we talk consent, but then let's make that consent more difficult. Let's take serious what the Article 29 Working Party, etc. Now, how would that fare? This is the last question, and then we go to the floor. How would that fare with the right to conduct a business?
I think when I hear this discussion, I think it's not necessarily up to the data subject to consent or not consent, because I think technology, as we see it behind us, has developed in such ways that it goes further than what you consent to. With regard to your question about the performance of a contract, there again you have this unclarity as to how far can you process the data. Is it specifically needed to perform the contract, or can you go beyond? And if you want to go beyond, then you can fall back into the legitimate interest. So it's like a never-ending chain of ways for data controllers at this moment to process the data. And then I thought back to maybe we could try and look at the accountability principle, and with the upcoming regulation, link it more towards the responsibility of data controllers to implement data protection by design, instead of just focusing on the responsibility of the data subject to consent or not consent with regard to technologies that we might not even understand. So that's the limitation of the freedom to conduct business in a way.
Thank you very much. I think it was very enlightening.
Well, very interesting discussion, and I'm very grateful everybody's keeping to the time. So now it's the time to open the floor for questions. There is a microphone in the middle of the room there. So I would ask people who want to ask the question to please queue in the microphone and ask from there.
So this one, yeah. All right. So thank you for setting up this panel. This is a really exciting topic. My name is Jean-Pierre Hubot from EPFL. I've been doing research on location privacy for the last 5 years, but exclusively from the technological point of view. So one point I would like to emphasize is something that Michael has mentioned, you know, this male solidarity after all. The crucial building block in this whole story of location privacy is the operating system that is on the smartphone. As you all probably know, nowadays 80% or so, more than 80% of smartphones are equipped with Android, an operating system that is provided by Google, right? Now, Google is, as we know, is a very successful company. Probably all of us are making use of their services. Their business model is not to protect data, right? And if you look into the details of Android, which we are probably not going to do in this session, yet still you notice that the system is not designed to protect the data at all, right? And this is no surprise, of course. So my question to those of you who are close to, who are in a position, which is not my case, but are in a position to influence the Commission or the European Parliament is, do you realize the magnitude of the challenge and the fundamental role of the operating system that is essentially controlling what the apps are allowed to do or not in such a way that the legislation is going to say something about what this piece of software is allowed to do or not, and the kind of features that it is going to offer to the end user in order to fine-tune what the smartphone will be allowed to do with the data.
Very good question. Do you want to direct it to anybody in the panel specifically?
I'm asking this to
the whole panel.
To the,
okay.
whole,
Who
to
would
the
like
whole
to,
panel.
to take up this question? I guess Rosa.
Just quickly, in terms of the current law, I think the current law already applies to the operating system provider, which acts as a data controller. And if you read the Working Party 29 paper, they explicitly refer to it as under the current law. So we have now the law, we have the authorities in charge, we have sanctions. Today, this could be already applied against the operating system. Now, when you look at the regulation gives, I think, new teeth or and a stronger that I think the authorities enforcing it will be able to use, which is the privacy by design rules. These might have a potential that today is weaker.
So I think Mireille.
Yeah. So just to be more specific, my understanding is that probably Google is willing to behave and to, as usual, I mean, to be a good citizen, but the framework has to be clear, right? So if you throw at me an article number, I'm lost. So I have no idea of what Article 29 or I don't know. This is not my vocabulary. So, but what is there a kind of dialogue existing between the regulator and Google about this topic? Or is it just that there are people in a room talking about this on one side and then Google does its own business? What's the status?
So I think Mireille has
to
add to this.
Yes. I would say that if the regulation comes up, and if part of that is the legal obligation to implement data protection by design, which means that an operating system has to comply with everything, all the rules in the regulation. This is not privacy by design, that's a very vague thing. It's an ethical concept. I'm talking about a legal obligation. That's one. The second is there's going to be a fine of 5%, let's say that waters down to 2%, of global turnover, not global profit. Now, I think that the current framework already offers a lot of opportunities, but they're not taken because the fines or the sanctions are scratches, or not even scratches, whispers on your skin. If you want to talk to Google, you mustn't talk to some privacy person there, but to the board. If you talk 2% global turnover, you will speak with the board, and they will definitely begin to read the clause on data protection by design. Data protection by design basically means, in combination with these fines of 2% global turnover, basically means that you are creating a serious market for data protection enhancing technologies. And if an operating system violates a data protection regulation, they will have to pay. And I'm sure that Google is more willing to listen to that than to all sorts of ethical pleas. I understand that they don't do evil, but I always say, we don't agree about what is evil. That's why we have the law. No, maybe they mean it. Actually, I'm sure many of them mean it. But we have invented the rule of law because we do not agree as citizens on what is evil and what is good. So we really need the law here and the implementation of the law.
Okay, thanks a lot. I don't want to monopolize the mic. Very quickly, do you know at what stage the dialogue with Google, is this just future music, or is it something that is already happening? Would you know?
I would like to say something, is that I represent the Commission. We propose laws. The laws go to Parliament and Council, and there is other entities, the national authorities, competent to enforce the law. So I don't represent them. I am in contact with them. I work with them, but I am not one of them. These questions should be answered by a national data protection authorities.
But can we maybe have an horizon? Is this something that might happen in 2 years, or in 5 years, or in 10 years, or in 50 years?
I mean, just by looking, not disclosing what they do privately, I think that you look at the news, you do see them enforcing the legislation upon Google and others. Now, in the case of operating systems, I really
well, but
don't.
for that, the new regulation has to be in place, right?
But the current regulation already would apply to an operating system who is a data controller. That is clear. I will look here in the room. I think you have a few, so okay. I can throw it of those in charge.
Okay, we're moving to the next question. We have. Hi. Thank you very much for your.
Yeah, thank you. I'm Javier Ruiz. I work at the Open Rights Group in the UK. We are a civil rights organization. We are part of EDRI. And for the past year, we've been looking at the use of location data and also some of traffic data by mobile companies in the UK to develop added services, for example, like being able to tell where people move to set up supermarkets or shopping malls. And what we found is actually a very different picture from what you have here. I mean, they completely refuse to acknowledge that there is any need for consent, because in theory, the data has been anonymized. So they're going through the other avenue completely. One company actually gives you an option to opt out. The other ones, they don't give you any option. And we have a very specific question that no one, including the ICO in the UK, has been able to answer, and we would like to throw it as a challenge, which is that what we are finding is that companies, when they talk about anonymization, in order to comply with the e-privacy regulation, what they're doing is actually to anonymize profiles of customers that include lots of location data, lots of traffic data, in some cases, or your web history. So we would like to see, do you think that this is the way that companies should be compliant with PECAR, with the need to make sure that the information no longer connected to the individual, or should they be anonymizing your location trace? So is it okay to work on the basis of profiles when we are looking at PECAR compliance? And then once that we move into anonymization and the future review of the e-privacy directive, there is a lot of research that seems to indicate that long enough location trace linked to an individual is pretty much impossible to anonymize. And what we are finding is also that in some of these profiles, some of the companies, they are putting very clear separation. They're actually sending the profile to a separate company they've set up. But some other companies, they're actually able to go back to that profile and query your consumption in order to, if you have a billing query, they can go back to your anonymous profile, re-identify it, and then say, well, actually, you have to pay a lot of money because you've been watching too many videos on YouTube, for example. And for us, those two questions seem at least a little bit breaches of the privacy regulation, but no one in the UK seems to be able to answer. So you will win a prize, any of you, and disclose. You can actually give us a conclusive answer on whether we should be pressing further on this or give up.
So you have actually two questions. One is the criteria to decide whether data is anonymous, and the second question is, even if the data were anonymous, did we solve all the privacy problems, or should we still be concerned?
The specific question is that all the companies, and we include, everyone agrees that the outputs of the process are anonymous, or whether they're aggregated or fully identified. What we don't agree is that the inputs of the process are fully anonymous.
Yeah.
That at the very best they are pseudonymous, and they definitely include lots of biographical information.
Yeah.
And the second is whether it's even possible at all, and whether the new review of e-privacy should acknowledge that location may not be anonymized.
So I would first like to ask Linnet to comment on not the regulation, but on the risks of data that have, even if they are not re-identifiable. I think she already spoke about in the opening statement. Maybe you can extend, and then we can maybe ask some of our lawyers to answer the other questions.
Thanks. It's a really good question. Yes, I'm starting to work on what constitutes identifiability and anonymity. Certainly pseudonymity is a huge problem. I would say that you have to look at the stakes as well. You have to look at what might be done with the data, and that depends on location too. I think that nobody is ever fully anonymous. You can't find a technology specialist who will say that anonymization is actually possible. Especially at phone companies, they can also identify you by your social network. It's important to remember. So the configuration of people you talk to and for how long and when and where those people are also identifies you. If you give your phone to a friend, the phone company knows that you've given it to a friend. And they know when the friend gives it back to you. And so we need to look even, I think your question is good, but you need to look beyond location traits. And yes, I think we need to address all parts of the process. I think companies need to be questioned about their inputs as well as their outputs. And I think you need to look at purpose in a broader sense. You know, what are the purpose problems attaching to reuse down the line, and how do you regulate that?
Sorry, in that one there is another question on the definition of value added, value for whom, and that is one of the things with all this big data analytics seems to be removed from any value added to the individual, and that we also, one of the ICO is able to answer that question. It seems like a bit of a tautological definition of value added, that no one is able to
adds
break.
value somewhere to somebody. So I want to ask Laura if you can comment a little bit on your opinion on how the legal framework deals with anonymous data and criteria for anonymization.
I think this is a subject that already came up when we researched if this is actually an effective technology to anonymize. And I think I agree with Linnet to say that anonymization is just something that is no longer possible. I think you always have to deal with inferred data. So even if you're going to anonymize a specific data subject, like you said, you might not have a phone, but you can travel with a companion that will have a phone, and for some reason the data has not yet been anonymized because it's needed for a specific service. So how does that relate to you if you do not use that service? So I don't think anonymization is actually a solution or an alternative to if the subject did not give their consent. Also, if, for instance, like Mireille said earlier, if you're going to accept sharing your location for a specific service, then you switch off the sharing mode. Like Linnet said as well, you have social networking sites. Maybe other friends will locate where you are, even though you did not accept. You have triangulation on your phone. You have Wi-Fi access points that you might not have thought about switching them off. So I think it's very, very difficult nowadays to rely on anonymization. So.
Just a very small, that if you look at the opinion on anonymization techniques of the Article 29 Working Party, they basically say that as long as somewhere a data can be connected with another data, additional data they call it, then it's defined as pseudonymous data, and it means the directive applies. And as we all know, under the upcoming regulation, there is going to be a light regime for properly pseudonymized data. So what I gather from what you described, there is a company that keeps the additional data, the identifiers, in another place, protected, but they can always at some point link back. So that is, in principle, personal data, and that means the whole framework applies.
Thank you very much. We move to the next question.
Thank you. Katarzyna Szymilewicz, Panopticon Foundation, also part of EDRI. Just one quick comment on the pseudonymization and new regulation. There is, of course, in the new draft from the Council, this idea that if this is pseudonymized data, you can use it for other purposes. So I guess unless we kill that, it will be triggered in this kind of situation, unfortunately. But my question is about something else. Thank you for bringing the consent issue in the context of localization and mobile apps to the table, because I think it's a crucial one. And what we see on the market happening more and more is this offer of extra service or value added in combination with consent. So the customer is being given this idea that if you consent to give us your localization, we will give you something extra. I think that's a very dangerous trend, because it's actually going against the very idea of consent, which should be, in my opinion, preserved for the situations of real choice. So if data or like localization is necessary for the value added, and I want the value added, there is no consent. It's just necessary for the service. I take the service or I leave the service. But if I don't want that extra service, I can always use whatever was the basic service offered to me. And I believe that this is very important, that as privacy advocates or regulators, we protect that consent from being devalued in the context of offered services. So my question to you would be whether you agree with this logic, and what do you think about the proposition in the new draft on the regulation coming from the Council, saying that you cannot even use the consent, as that consent will be invalid in the context of services where there is no alternative. So imagine there is one monopoly offering location-based services, and it's trying to get your consent, but there is no alternative on the market. The Council is trying to say you cannot even ask consent in this context because it won't be free and real consent. Do you agree with this logic, and to what extent you think it doesn't contradict the e-privacy directive?
Thank you for the question. I'm going to give the microphone to Mireille, and then we will ask Rosa to comment on this.
Yes, I'm going to add something to your question, Rosa. Wouldn't it be an excellent idea now to throw the whole consent out of both the e-privacy and the data protection directive, and to say, if you want to process data, show me that it's necessary. If not, no data.
I like this idea.
It's a reformulation of your question.
Thank you.
You caught me. I wouldn't need to think. I would feel uncomfortable to allow the processing of data without any sort of individual ability to say no.
It's a very radical proposition that Mireille is making.
I would feel uncomfortable.
Yeah. If I may say something about this, I would think that would move the battle to what is necessary. And then the game would be, okay, how do I define my service in a way that the data I want is necessary for the service that I'm offering? So, because necessary is also sort of a fuzzy concept. And already, like, things that we would, location information that we would think is necessary for providing certain services. We do have advanced technologies that can do without actually disclosing this location data to the provider. So does this mean that this data is no longer necessary? Where do we draw the line? So I think that is also a very hard issue. I'm going to take we have a long queue there, so.
It's funny to queue. Eleni Costa from Tilburg University. Thank you for the exciting discussion. And well, I have two questions, but I will start with my second one, actually, just to follow up on the previous speaker. So talking about consent. And yeah, I know why you're laughing, but one of
Eleni did her PhD on consent, so we have an expert in the...
Yeah, and I got in depression after finishing it because consent has all these issues that we are discussing now. But something that I think would be very interesting to bring into the discussion with regard to consent is that this is not a new debate in relation to location data. Okay, so there are other fields that we can look into, see what is happening in those areas with regard to consent, and get some lessons learned, bad experiences, good experiences, whatever. So one of these areas is something that everybody here is familiar with and has to do with cookies. So the regulation of cookies, should we rely on consent, should we not rely on consent, etc. So what is interesting in this debate is that okay, I'll be quick. The Dutch Data Protection Authority issued an opinion. So my Dutch colleagues, I guess, are familiar with it, on whether users should be giving their consent for the installation of cookies in order to access the website of the public broadcaster. And there, the Dutch DPA made very interesting observations with regard to something that I hope I translated properly, was called like factual monopoly. And it said when you have a de facto monopoly, when you have a factual monopoly, like in the case of the public broadcaster, then consent should not be a ground to rely on. I mean, that's very briefly, I mean, it's a very long discussion. So maybe this is something that we want to think about in relation to one of the points that Mireille raised earlier. When should we rely on consent or not? So just one thing that I would like to hear your thoughts about. The second thing is we mix the discussion, a lot of issues relating to the General Data Protection Regulation. So we heard about proposals of the Council, what does the Parliament say, etc. But I think we are forgetting the most important thing. No matter how many changes we make to the GDPR, as long as Article 9 is there, which is a specific rule that regulates the processing of location data for value-added services, we will still have the same problem. So, because I know that Rosa and her colleagues, they are at this moment discussing the prospect of revising the privacy directive, I think we need to put more emphasis than what we actually do on how and to which direction should we revise Article 9. Thank you.
Thank you very much. You want Rosa to respond to this question, or?
Anybody. I mean, I know Rosa does not have answers at this moment,
yeah.
And Rosa, I think, needs feedback from all of us on what they should be doing.
Okay. Anybody wants to take up
Let's
the question?
just say that Eleni is part of this contractor who is helping us to answer these questions.
So she's raising the difficult ones that she knows there are no answers for. Do you actually, Eleni, have answers to the questions do you have any suggestion on how these questions can begin to be answered?
No, not as such. I'm not here to give the... I hope I was able, but every time I have a suggestion, there are always the counter-arguments. Like, we need to rely more on necessity. We need to rely more on the finality principle. And then, again, you get into this debate. How do you frame them? So I'm very confused myself. With my colleague, Ronald Linnet, we have been discussing these days a lot about where the focus should be in order to have effective protection of personal data, not only in relation to location data, but broader. I don't have the brilliant idea, but I think we really need to focus the discussion on the important points in order to move on. Because I think we are losing too much time discussing, will it be 7F or will it be 7A, and what happens if we have, sorry for the numbers, for the ones that are not familiar with them, like do you rely on, which ground do you rely on, and what happens with the specific and explicit requirement for consent in relation to location data. To me, that is extremely problematic.
Yeah. Thank you very much. You want to say something, Mireille, or anybody in the panel? Okay, we have time, I think, for one more question.
Hi there, my name is William Morland, I'm from Palantir Technologies. I think one of the issues that hasn't been touched on is that we've looked at it from the frame of an individual giving away their location data from a device, but a lot of location data is public in the sense that most of our travels are in public, and so when we encounter issues such as automatic number plate recognition, or in a shopping mall where it's monitoring our phone device, people justify that by saying this is public data, it's your public whereabouts, this shouldn't be covered by personal information. Do we need to reclassify how we control public data or open data so that when it's personally sensitive or could be linked back to you, for example, a number plate which will then inherently link to a specific person, do we need to change our laws so that we make that more sensitive information?
Are you directing the question to any specific panelist, or?
I'd be particularly interested in Laura and Rosa.
Okay, so Laura and Rosa.
I think this is also a debate of public-private and how do you interpret that. And I think it doesn't matter if you're in a public space, you still have the right to privacy. And so if you say like the number of your car, the license plate, for me that is personal data because it can be directly identifiable and linked back to the data subject. So then the data protection directive applies. So then you have kind of the protection. If you're in a shopping mall and you're being monitored via your device, again, same principle. It's not because I feel like that if you're in a shopping mall, that you're supposed to have this reasonable expectation of being tracked or being monitored. But then again, yeah, I think the law may be interesting. Well, it gives answers as soon as it applies, but if it's unsure whether the person is identifiable, I think we can, for now, only rely on like case law to see when your privacy is when you can expect privacy. So I don't know if Rosa needs to.
I completely agree. I have nothing to add. I fully agree with Laura's answer.
I think we have run out of time. I'm sorry we could not take more questions. I know there were people. Thank you very much for the attention, and I hope we enjoyed the panel.